So now we're going to talk about the crimes against the person. And honestly, this is where criminal law starts becoming very real for many students. Up until now, we've talked about criminal law theory, mens rea, actus reus, the punishment philosophy, and even the constitutional structure. But now we're shifting into offenses that involve direct harm or threatened harm against human beings. Crimes against persons often generate some of the strongest reactions in society because they involve offenses of violence, fear, bodily harm, death, trauma, sexual violence, intimidation, and even personal safety. Okay. So one thing I want you to think about during this chapter is that criminal law is not just punishing conduct. It is also categorizing human harm. So the legal system attempts to distinguish between intentional violence, reckless violence, negligent harm, threats, intimidation, accidental death, consensual conduct, and even coercive conduct. And those distinctions become incredibly complicated because human behavior itself is complicated. So throughout this lecture, we're going to examine things like homicide, assault and battery, kidnapping, etc. And as we move through these topics, I want you to pay attention to how criminal law constantly balances, or attempts to balance, I should say, intent, harm, consent, fear, constitutional rights, and public safety. Now, before we begin discussing the individual crimes, we need to talk briefly about how criminal law categorizes offenses generally. Most jurisdictions recognize three broad categories of crime. You have the crimes against the person, against property, and crimes against the public. Okay? And crimes against the person involves direct harm or threatened harm against the human beings. So again, that's against their body, their safety, their liberty, even their psychological security. These all become a central focus. That's why we're looking at examples of homicide and assault and kidnapping and battery, things like that. Now, crimes against property focuses primarily on interference with ownership or possession of property. So that would be like your burglary, your theft, your robbery, your arson, fraud, vandalism, things like that. Now, crimes against the public involve conduct viewed as harmful to society more broadly rather than targeting one individual victim specifically. So examples could be like prostitution or disorderly conduct, drug offenses, gambling violations, and certain public morality crimes. And some crimes overlap categories. For example, robbery involves both violence against a person and theft of property. And that overlap demonstrates something, important about criminal law, and that is that human behavior rarely fits perfectly into clean categories. Now, another foundational concept that you need to understand is the idea of a lesser included offense. A lesser included offense is a crime whose elements are completely contained within that of a more serious crime. Okay, and this becomes incredibly important during charging decisions, plea negotiations, and even jury deliberations. So, for example, some prosecutors charge someone with armed robbery. Well, armed robbery may require proof of theft or force and use of weapon. Okay. Now, if the prosecutors fail to prove the weapons element, a jury might still convict on the lesser offense of robbery if those elements were proven, okay? So the lesser offense is included within the greater because the greater offense contains all of the elements of the lesser crime plus any additional aggravating factors. Now, this also connects to the concept of merger, and merger occurs when a lesser offense becomes absorbed into a more serious crime. For example, simple assault, that can merge into aggravated assault if the greater offense is proven. So the defendant is not punished separately for like every overlapping component. Now, some might think that a criminal trial is simply just asking, like, did the defendant do it? But legally, prosecutors have to prove every required element of every offense individually beyond a reasonable doubt. So it's not just the whole. And the burden at that point matters tremendously. Many criminal trials become battles basically over whether one specific element can actually be proven and not necessarily the crime as a whole. Now, homicide is one of the oldest and most serious crimes recognized in criminal law, and homicide simply means the killing of one human being by another. Now, sometimes people hear the word homicide and they automatically assume murder, right? But legally, homicide itself is a neutral term. Not every homicide is criminal. For example, you have self-defense killings, you have justified police shootings, you have wartime killings, accidental killings, and even some negligent deaths, and those can all technically qualify as homicides without necessarily constituting murder. Okay? Now, common law defined murder as the unlawful killing of another human being with malice aforethought. Now, malice aforethought sounds dramatic and old-fashioned, but the concept is actually extremely important. This refers to a sufficiently blameworthy mental state that is supporting murder liability, okay? And honestly, one of the biggest challenges in homicide-type laws involves determining the intent, the planning, the recklessness, the provocation, and even the moral blameworthiness, okay? Now, the first major element in homicide is the actus reus, which is the unlawful killing itself. All right, and that immediately raises another legal question. What legally counts as death? Now, historically, death focused on the cessation of breathing and the cessation of a heartbeat. All right, but modern medicine has complicated this like tenfold. All right. So today, many jurisdictions recognize brain death. And brain death generally refers to irreversible cessation of brain function, even where machines may temporarily maintain circulation and or, respiration. So developments in medical technology forced criminal law to adapt because modern medicine can artificially sustain biological functions in ways that earlier legal systems could have never anticipated. Implied murder. Okay, so suppose that someone committed an extremely dangerous felony and another person died, even though the death itself was not specifically intended. All right, well, common law developed doctrines allowing murder liability in certain situations because otherwise highly dangerous conduct causing death might go insufficiently punished. All right. So this becomes one of the major controversies in homicide law, and that is how much intent should murder actually require. And we're going to dig into that more as we kind of go through each one of these. But let's start with the felony murder doctrine. And this is one of the most controversial homicide doctrines in criminal law. And people tend to have very strong reactions to felony murder because it does dramatically expand murder liability beyond just intentional killings. Under the felony murder rule, a person can be guilty of murder if the death occurs during the commission or attempted commission of certain felonies, even if the death itself was not intended. Okay? So pause for a second. This is incredibly important. Like, really think about this. So if you have two individuals who commit an armed robbery, right? And during the robbery, let's say that the store clerk suffers a heart attack from the, anxiety that's being caused by all of this, the shock to the system. Or you have a co-defendant who accidentally shoots someone. Or even a police officer fires a weapon and kills a bystander, or your, friend who's doing this with you. Well, under the felony murder rules, participants in the felony can still face murder charges even if they never intended anybody to die, they did not personally kill somebody, or they did not anticipate the death occurring. Okay? And this is what makes this doctrine generate enormous debate. Supporters argue that felony murder discourages dangerous felonies and it holds offenders accountable for foreseeable risk that are created by violent criminal conduct. But critics argue that felony murder sometimes punishes individuals as murderers even where murderous intent never existed. Okay? Now, let's look at it a little deeper. Felony murder generally requires a few things. One is the commission or attempted commission of a qualifying felony. All right. You have to have a death that occurs during the felony, and then you have to have a causal connection between the felony and the death. All right. Now, not every felony automatically qualifies. Historically speaking, felony murder often focused on those that are inherently dangerous. All right. Robbery, rape, burglary, arson, and kidnapping. All right, which actually we typically call it BARK, B-A-R-R-K. So burglary, arson, rape, robbery, kidnapping. And those are sometimes called predicate felonies. All right, now, another important thing to take note of here is accomplice liability. So suppose that several people commit a felony together. Well, under accomplice liability, one participant can be held criminally responsible for the actions committed by another participant during that crime. All right. So people are often like surprised by how broad accomplice liability can also become. So if you have someone who is acting as like a getaway driver or a lookout, or they're just helping to plan or facilitate, they can still face serious criminal liability, even if they never physically harmed anybody themselves. Okay, so criminal law, again, often focuses not only on direct actions, but also participation in general, in the dangerous, criminal conduct in general. Now, another important category involves misdemeanor manslaughter, and this applies when a death results from the commission of a misdemeanor rather than a felony. So the misdemeanor manslaughter results in lower homicide liability than felony murder because the underlying conduct is viewed as less inherently dangerous. But you still have criminal liability that might exist because unlawful conduct, contributed to a death. Now, I know some might struggle with this because the death itself may be entirely unintended, but criminal law asks, should individuals bear responsibility when unlawful conduct creates foreseeable risk leading to death? Okay. And honestly, reasonable people, I should say, disagree about where those boundaries should exist. All right. Now, this slide also does talk about the communicable diseases in homicide. And this is an area of law that has become increasingly complicated in modern society. So suppose someone intentionally exposes another person to a deadly, communicable disease, but they're fully aware of those risks. Could criminal liability exist? And potentially, yes. In some jurisdictions, intentional transmission of serious diseases can support charges like attempted murder or, assault or reckless endangerment or homicide if death occurs. Now, those cases become legally and ethically complicated very, very quickly. Like, what if the exposure was reckless rather than intentional? What if the person did not fully understand transmission risk? What if the symptoms appear years later? What if proving causation becomes difficult? All right. And causation, it does become a huge issue here because these communicable diseases often involve delayed symptoms. You've got multiple possible exposure sources. You have complicated, medical evidence, and then you have scientific uncertainty. Now, another complication involves balancing public health with, privacy rights and criminal accountability along with stigma. And critics sometimes argue that criminalizing disease transmission can discourage, testing and treatment and even disclosure. So supporters argue that intentional exposure creates serious harm and it deserves criminal accountability. All right. Again, criminal law is constantly intersecting with, medicine and ethics and public policy and science. The list just basically goes on and on. Now, modern statutory approaches to homicide generally divide murder into degrees, and first degree is usually considered the most serious form of criminal homicide. This generally involves willful, deliberate, and premeditated killing. All right. Premeditation means the defendant formed that intent before acting. And I know that some might imagine that premeditation requires like an elaborate scheme or, weeks of planning, long-term preparation type stuff, right? But legally, premeditation may, form very quickly in some jurisdictions. The key issue is whether the defendant had time to reflect and consciously decide to kill someone rather than acting, purely impulsively. First degree often involves planning, motive, preparation, concealment, and or evidence suggesting, intentional targeting. So like lying in wait, poisoning, murder for hire, carefully planned shootings, things like that. Second degree murder, honestly, this is kind of like a catch-all. It usually lacks premeditation, but it still involves serious malice or intentional violence. So like if you have two people who get into an argument that suddenly escalates into deadly violence, right? If that killing occurred intentionally, but without meaningful reflection or planning, then second degree murder may apply better, as opposed to first degree murder. But distinguishing between first degree, second degree, manslaughter and negligent homicide becomes that difficult task in criminal law because, again, human behavior rarely fits neatly into categories. And so juries are going to spend enormous amounts of time, evaluating intent and planning and was there provocation? What was the emotional state? Recklessness and even like surrounding circumstances in general. But again, this type of law is going to attempt to categorize those different levels of human blameworthiness. Now, criminal law also recognizes situations where homicide liability might be reduced because of the mental state of the defendant, and that it's viewed as less morally blameworthy than murder, okay? An example might be like an intent to cause serious bodily harm rather than an intent to kill. So if someone violently attacks another person intending severe injury, but not specifically death, if that victim dies, then murder liability may still exist because intentionally inflicting, serious bodily harm creates an obvious risk of death. Now, closely related to this idea is the deadly weapon doctrine. And the deadly weapon doctrine allows the juries to infer intent from the use of inherently dangerous weapons. So, for example, if someone points a loaded firearm at another person and fires at close range, then jurors may reasonably infer intent to cause serious harm or death exists. Okay. Same applies to like knives and explosives, vehicles used intentionally as weapons, and then other inherently deadly conduct. All right. And I know somebody might ask, like, what if the defendant says they didn't mean to kill anybody, which is what a lot of them say. Criminal law often responds by examining like the nature of the act, the totality of the circumstances, what was happening in those surrounding circumstances, and then, the obvious risks that are involved. Some conduct is so dangerous that intent may reasonably be inferred from the behavior itself. Last but not least on this slide is involuntary manslaughter. And this generally involves unintended killings that result from recklessness, criminal negligence, or unlawful conduct. And examples are going to be things like drunk driving fatalities, reckless firearm handling, fatal street racing, dangerous neglect, or negligent conduct causing death. Okay, now notice the distinction there. The defendant may not specifically intend death, right? But criminal liability still exists because the conduct treated, it's treated in the same because it's created unreasonable and substantial risk, right? And this becomes one of the most important ideas in criminal law because sometimes criminal liability attaches not because someone intended harm, but because they consciously disregarded an obvious harm. Now, manslaughter occupies that important kind of middle ground in homicide law. And traditionally, manslaughter involves the unlawful killing of another person without the malice aforethought. So in more simple terms, the killing is criminal, but the circumstances reduce moral blameworthiness compared to murder. All right. And one major concept here is provocation. So provocation occurs when circumstances would cause a reasonable person to lose emotional control and respond violently. All right. So historically, courts often recognized situations involving things like discovering adultery, a sudden physical attack, or some sort of extreme confrontation. So modern courts evaluate provocation much more carefully because society no longer accepts many historically recognized excuses for violence. And honestly, provocation law became controversial because historically it's sometimes reflected, sexist assumptions or positive attitudes and even unequal treatment. For example, let me think. Historically, some courts treated discovering adultery as strong provocation, reducing murder to manslaughter. Well, modern courts increasingly question whether jealousy or emotional rage should meaningfully reduce homicide liability. Okay. Another important issue is the cooling off period. And provocation generally requires the defendant to act, before a sufficient time passes for reason and self-control to return. So, for example, suppose someone becomes enraged, during a sudden confrontation and immediately responds violently. Well, that situation differs from someone who is calmly planning retaliation a few days later. Okay. So the law generally views this calculated revenge differently than immediate emotional reaction. All right. Self-defense is also another important concept. And a perfect self-defense completely justifies homicide when lawful requirements have been satisfied. But an imperfect self-defense exists when someone honestly but unreasonably believes that deadly force was necessary. So in some jurisdictions, imperfect self-defense reduces murder liability to manslaughter rather than completely excusing the killing, okay? And those cases become extremely difficult because juries have to evaluate things like their fear and their perception and their reasonableness and their trauma and how rapidly, was this situation unfolding. So human beings under stress don't always think clearly or rationally, and criminal law attempts to evaluate those realities while still protecting public safety. Now, the Model Penal Code takes a somewhat different approach to homicide than traditional common law classifications. The Model Penal Code classifies criminal homicide into murder, manslaughter, and negligent homicide. And honestly, one reason that the Model Penal Code became influential is because it attempted to create more clear, more consistent standards regarding criminal mental states. Now, under the Model Penal Code framework, homicide liability often depends heavily on 4 mental states: purposeful, knowing, reckless, and negligent conduct. So a purposeful killing involves conscious intent to cause death. A knowing killing is going to involve awareness that death is practically certain to occur. Reckless homicide involves conscious disregard of substantial risk. And then negligent homicide involves failure to recognize risk that a reasonable person should recognize. Now, those distinctions matter tremendously because criminal law generally punishes intentional killings more severely than reckless killings, and reckless killings more severely than negligent conduct. All right. Another major issue that is discussed here is involving the definition of human life itself. And honestly, homicide law intersects with some of the most controversial ethical and political debates in society. For example, questions involving abortion, fetal homicide, brain death, life support, and personhood. All of these create enormous legal disagreements. Some jurisdictions recognize fetal homicide statutes under certain circumstances. Others focus heavily on viability standards or separate constitutional considerations. And honestly, these debates demonstrate something important about criminal law, and that is that it's not purely technical. It reflects broader societal beliefs regarding morality and bodily autonomy and life and death and, medicine and even government authority. Now, another historically important issue is suicide. So, under Old English common law, suicide itself was treated as a crime. Today, it is generally not criminalized in the United States, but criminal liability can still exist for assisting suicide, encouraging suicide, or even coercing vulnerable individuals towards self-harm. All right. Now, this area becomes increasingly controversial in discussions involving things like physician-assisted death, terminal illness, bodily autonomy, and even end-of-life care. Some states permit limited physician-assisted, dying under highly regulated conditions. Others, it's prohibited entirely, okay? Now, these issues involve some very profound ethical debates regarding things like autonomy and suffering and dignity and religion and medicine and state authority. The list, it just goes on, but very controversial. Another important concept introduced here is corpus delicti. This literally means the body of the crime. Now, you might misunderstand this phrase and assume that it always requires finding a physical body, and that's not necessarily true. Corpus delicti generally means that prosecutors have to prove that a crime actually occurred and that the harm resulted from criminal conduct. So, for example, a confession alone is not usually enough, all right? Suppose someone falsely confesses to a murder, but investigators cannot establish a death or criminal conduct or even any evidence supporting the confession, right? Additional proof is generally required because history demonstrates that people sometimes falsely confess, due to coercion and fear, exhaustion, manipulation, mental illness, psychological vulnerability. This list goes on and on as well. But wrongful conviction history demonstrates why corroboration of information matters so much. The legal system generally requires evidence establishing that a crime actually occurred before criminal punishment is imposed, okay? And because criminal law recognizes, the fact that confessions alone are not always reliable. Now, after homicide, we move into another major category of crimes against the person, and that is assault and battery. And students are often surprised to learn that these are technically two separate crimes, even though it is one that definitely gets used interchangeably in everyday conversation, okay? Legally, assault and battery protect slightly different interests. So assault primarily protects people from fear and threatened violence, whereas battery protects against unwanted physical contact or bodily harm. Now, assault generally involves an intentional act that's creating reasonable fear or apprehension of imminent harmful conduct or contact, rather. And that's important because physical contact is not always required for assault. So suppose that you have someone who points a loaded firearm at another person and threatens to shoot them. Even if no shot is fired, an assault may still exist because the victim experiences immediate fear of harm. All right. Now, one important requirement here is awareness, and the victim generally must actually perceive the threat. So if someone swings a fist like behind another person who never sees the attack coming, that may not qualify as apprehension assault because the victim never experienced awareness of the imminent harm itself, right? Another form of assault involves an attempted battery. And that occurs when someone attempts a harmful physical contact, but they actually fail. So if someone, say, swings a baseball bat intending to strike somebody, but they miss completely, even without contact, assault liability can still exist because the defendant attempted unlawful violence. All right. So assault law demonstrates something important, and that is that the legal system protects not only against physical injury, but also against the fear and intimidation that can come with it. Because threatened violence itself can honestly create serious psychological harm. Now, battery is different because battery requires physical contact. And sometimes people imagine that battery only applies to severe injuries or extreme violence. But battery can involve even relatively minor physical contact if the touching is considered offensive or harmful or non-consensual, right? So punching someone obviously qualifies as a battery, but depending on that circumstances, so might spitting on somebody or grabbing someone aggressively or unwanted sexual touching or intentional shoving involving another person. The key issue is not necessarily the severity of the injury. The issue is whether the contact was unlawful and offensive or harmful. Okay? So consent becomes incredibly important here. Like in sports, okay? People consent to certain physical contact within the rules of that activity. Like football players expect to be tackled. Boxers consent to being punched within the regulated competition, right? But conduct that exceeds that expected or those lawful boundaries may still create criminal liability. Now, assault and battery charges often become aggravated when additional factors exist. That would be like the use of a deadly weapon, serious bodily injury, attacks against vulnerable persons, assaults against law enforcement officers, or like violence committed during another felony. The aggravated assault cases are often going to involve questions regarding intent, weapons, the degree of injury, and the risk of death. All right. Again, it's categorizing those different levels of harm and the blameworthiness. Now, one of the older common law crimes is mayhem. And mayhem involved inflicting or intentionally inflicting severe and permanent bodily injury or disfigurement. All right. That means like cutting off limbs, blinding someone, dismemberment, permanent disfigurement, things like that. Okay. So the mayhem statutes developed historically because societies viewed permanent bodily mutation as especially severe and socially destabilizing, essentially. So it might be, in the earlier legal systems, losing an eye or losing a hand or another major body part, could dramatically affect a person's survival. It could affect their employment, their social status, all of those things. The modern criminal statutes, though, they often classify those acts under aggravated battery or aggravated assault, maiming, or serious bodily injury offenses. Okay. Now, one thing you should notice here is that criminal law often punishes permanent injury more severely than temporary. And that's because the permanent injury is going to fundamentally alter a person's life. So modern courts evaluating serious bodily injury often consider things like a long-term disability, scarring, chronic pain, loss of bodily function, and then even permanent disfigurement. So again, criminal laws, they evaluate not just the intent, but also the severity of that harm. All right, so now we're moving into one of the most sensitive and controversial areas of criminal law, and that's sex crimes. And honestly, this area of law has changed dramatically over time because societal attitudes regarding, gender and consent to marriage, sexuality, privacy, and even bodily autonomy have evolved significantly. Historically, rape laws were often deeply flawed and reflected outdated assumptions about gender roles, resistance, victim behavior, credibility, all of those things. right? But modern criminal law increasingly focuses on consent and coercion, force, incapacity, and exploitation. All right, so rape generally involves sexual intercourse imposed by threat, coercion, force, or without legally valid consent. And sometimes people want to oversimplify consent issues, but legally, consent can become extremely complicated. You have questions that can involve intoxication, age, unconsciousness, mental incapacity, coercion, threats, manipulation, and even abuse of authority. Many sexual assault cases become legally difficult because they often involve conflicting testimony, delayed reporting, credibility disputes, trauma responses, and even limited physical evidence. One other thing that is talked about here is recidivism among sexual offenders. And recidivism refers to repeat offending. Now, public concern regarding repeat sexual violence is heavily influenced by, notification statutes, civil commitment laws, monitoring requirements, registration laws, all of those things, right? And those laws continue generating major constitutional and ethical debates involving things like public safety, rehabilitation, privacy, due process, and even punishment. Now let's talk about statutory rape. These laws criminalize sexual activity involving minors who are legally incapable of consenting due to age. And honestly, this area of law becomes extremely controversial because it involves questions about, consent and maturity and exploitation and even age differences. And it can become very emotionally and politically charged, to say the least, honestly. Statutory rape is often treated as a strict liability offense in most jurisdictions, and that means that, mistake regarding age may not eliminate criminal liability, even if the minor lied, used fake ID, or even appeared older. And this is where we often see debates about whether or not that feels fair, right? Supporters will argue things like strict liability strongly protects minors from exploitation, whereas critics will argue that, harsh liability may sometimes apply in situations lacking predatory intent. And some jurisdictions attempt to address this through things like close in age exemptions, your Romeo and Juliet laws, and even through, sentencing distinctions. But there is the important issue of consent capacity, all right? And legally valid consent generally requires the ability to understand the situation, to voluntarily agree, and to exercise meaningful choice. So individuals who are unconscious or mentally incapacitated or heavily intoxicated or legally underage may lack the capacity to consent, okay? And modern criminal law increasingly focuses less on requiring victims to physically resist and more on meaningful consent actually existing, all right? And that shift reflects the broader societal recognition, regarding trauma and fear, coercion, intimidation, and even a power imbalance. Now, there's another issue that involves the digital sexual exploitation. And modern technology has created entirely new categories of criminal conduct, involving things like online exploitation, non-consensual image sharing, sextortion or child exploitation materials, cyberstalking, or internet-based solicitation. All right. Criminal law honestly struggles to adapt to rapid evolving technology because modern communication, it creates opportunities for exploitation that the legal system never really previously encountered. Now, while we're on the topic of rape, let's talk about marital rape. Historically speaking, many legal systems did not recognize rape within a marriage because wives were viewed as having permanently consented to sexual relations through the marriage itself, okay? And that historical rule reflected very deeply unequal assumptions regarding gender and marriage and autonomy and even property rights, all right? Now, modern law overwhelmingly rejects those assumptions. So marital rape is criminalized in all states, although there are procedural differences or maybe evidentiary distinctions that still exist in some of those jurisdictions. But the shift reflects, again, broader recognition that marriage, it doesn't eliminate bodily autonomy or consent rights. We also have issues regarding sexual harassment and abuse of authority. You know, criminal liability can also arise where individuals exploit their professional authority or their custodial authority, educational positions, or just a power imbalance in general to coerce that sexual conduct. So that might be like corrections officers, teachers, therapists, medical providers, or even supervisors. All right. So consent becomes much more legally complicated when the major power imbalances exist because apparent, quote unquote agreement may not truly reflect a free choice where there is authority, dependency, fear, or coercion that influence the situation. And again, modern, criminal law reforms, they increasingly recognize the role that power dynamics play in the sexual exploitation of others. So now let's talk about sodomy laws. And this is one of those areas where criminal law, morality, privacy, sexuality, and constitutional rights have historically collided. All right, so traditionally, sodomy statutes criminalized what older laws referred to as unnatural sexual acts. All right, so that language itself tells us a lot about how these laws developed because they were often rooted in moral, religious, and cultural judgments about sexuality rather than harm-based criminal law. Historically, sodomy laws were used to criminalize certain private sexual conduct, including oral sex, anal sex, and especially same-sex intimacy. And in many states, those statutes technically applied broadly, but in practice, they were often enforced disproportionately against LGBTQ people. That created an important question for criminal law. Should the government be able to criminalize private, consensual sexual conduct between adults simply because a majority of society disapproves of it? And that question eventually became a major constitutional issue involving privacy and liberty. For a long time, courts allowed states to enforce sodomy laws, but modern constitutional law shifted significantly with Lawrence v. Texas, where the United States Supreme Court said that adults have a protected liberty interest in engaging in private, consensual sexual conduct without government intrusion. So that decision was important because it recognized that criminal law cannot simply be used to enforce, moral disapproval of private adult intimacy. Now, that doesn't mean that all sexual conduct is constitutionally protected. Again, consent remains critical. Age remains critical. Capacity, coercion, force, abuse, exploitation, public, conduct. All of those things can still be criminalized, all right? And the key distinction is this. The law may criminalize sexual conduct that involves force, coercion, minors, incapacity, exploitation, public harm, all those things. But after Lawrence, states cannot generally criminalize private consensual sexual intimacy between adults simply because lawmakers consider it immoral, all right? And honestly, the sodomy laws are a perfect example of how a criminal law evolves as society changes. They also show us that criminal statutes are not always neutral. Sometimes criminal law has been used to enforce social stigma, to punish marginalized groups or even to impose the moral majority's opinion, right? So as future legal professionals, you need to be able to recognize that that history, because the law is not just a set of rules. It does reflect power, it reflects values, and sometimes it reflects prejudice. So when we study the sodomy laws, we're not just studying an outdated category of sex crimes. We're studying the boundary between legitimate, criminal regulation and unconstitutional government intrusion into private life. Now let's talk about the rape shield laws, because those laws dramatically changed the way sexual assault cases were handled in American courts. Historically, sexual assault victims were often treated like they were the ones on trial. Defense attorneys frequently introduced evidence about, a victim's prior sexual history, their relationships, their reputation, clothing choices, lifestyles, all those things in an attempt to attack, the credibility or to imply consent. And honestly, the reasoning behind this historically reflected some of those deeply problematic assumptions. For many years, courts and society often treated women who were sexually active as somehow less moral or less believable or more likely to have consented, right? And that mindset kind of created a lot of problems because it discouraged victims from reporting assaults at all. Many victims feared that reporting a sexual assault would result in public humiliation, intrusive questioning, character assassination, or exposure of intensely personal details unrelated to the alleged offense. So rape shield laws were designed to address those problems. Now, generally speaking, rape shield laws limit the ability of attorneys to introduce evidence involving a victim's prior sexual behavior or sexual reputation when that evidence is irrelevant to the issues being decided at trial. Now, one thing you need to understand immediately is that rape shield laws does not mean that anything involving sexual history is automatically banned forever, right? The issue is relevance. Courts still have to balance two extremely important interests. You have the defendant's constitutional right to present a defense, and you have the victim's right to be protected from unfair prejudice and irrelevant attacks. So, for example, suppose that DNA evidence becomes a major issue in a sexual assault case. If the defense argues the physical evidence came from prior consensual relations between the defendant and a complainant, then a court may allow limited evidence directly related to that issue because it may be relevant to the defense. But what courts generally try to prevent are broad attacks such as, well, she's dated a lot of people, or she's had a lot of prior sexual partners, or look at what she was wearing. She was dressed provocatively, right? So modern courts increasingly recognize that those kinds of arguments often rely on stereotypes rather than legitimate legal relevance. And one of the important things, the important principles behind the rape shield law is that past behavior does not automatically imply consent. The principle seems so obvious to many people now, all right, but historically, the legal system did not operate that way. I'm trying to think. One other thing. Rape shield laws are also an attempt to reduce re-traumatization, okay? Sexual assault victims already face, a lot of enormous emotional strain from reporting, medical examinations, interviews, investigations, and even the testimony aspect. So allowing unlimited invasive questioning about unrelated sexual history often intensifies that trauma dramatically. Now, again, it doesn't mean that sexual assault trials become unfair to defendants. They still have a constitutional right, more specifically, involving due process and confrontation of the witnesses and cross-examination and the right to challenge evidence. So the courts have to try and balance the fairness to the accused against the protection of the victim from, any sort of irrelevant humiliation and prejudice. But rape shield laws, they present one of the clearest examples of criminal procedure evolving alongside, the changing societal standards or the understandings of trauma and consent and victimization and even gender bias within the legal system. Now let's talk about incest, which is one of the oldest prohibited sexual offenses in legal history. And it generally refers to sexual relations between individuals who are closely related by blood, or in some jurisdictions, certain family relationships that are created through marriage or adoption. Now, you should recognize immediately that the incest laws developed long before, modern criminal justice systems existed. And historically, these prohibitions were rooted in, religious tradition, family structure, social stability, inheritance concerns, and protection of vulnerable family members. Different jurisdictions define prohibited relationships differently, but incest laws commonly involve relationships between parents and children, siblings, grandparents and grandchildren, and other close familial relationships. Now, modern criminal law approaches incest very differently than the older legal systems did. Historically, the incest laws often focused heavily on morality and social taboo, but modern criminal law focuses more on power imbalance, coercion, abuse, exploitation, and protection of vulnerable individuals within family systems. And honestly, many incest cases involve very enormous differences in authority, maturity, dependency, and even emotional control. So, for example, relationships involving parents and children inherently involve a profound power imbalance. Parents possess authority, influence, and control that can make genuine, consent legally and psychologically impossible. Now, one other thing to recognize is that incest cases often involve very delayed disclosure. Victims will remain silent for years out of fear and shame, family pressure, financial dependency, manipulation, and even through their own emotional trauma. Some victims fear, destroying their family, or not being believed, or losing housing, or the retaliation from family members. And honestly, those cases can become extremely emotionally complicated because families themselves may become divided regarding, credibility and loyalty, protection and denial. Another issue that we hear used a lot is grooming. Grooming refers to the manipulative behavior that's used to normalize inappropriate conduct and to gradually gain control over victims, both emotionally and psychologically. And in family abuse situations, grooming can involve secrecy and special treatment, isolation, emotional manipulation, and even creating confusion about boundaries and consent. All right? Now, the laws increasingly recognize that exploitation may exist even where overt physical force is absent. Sorry, I'm getting over a cold and my brain is still not fully there. So psychological control, authority, dependency, and manipulation, they can all undermine meaningful consent. All right? These cases can present evidentiary difficulties because abuse may occur privately. It may occur over very long periods of time without witnesses and sometimes without immediate physical evidence. So prosecutors will often have to rely heavily on, disclosures and victim testimony, behavioral evidence, surrounding circumstances, communications, all of those things. And those cases force the courts and the juries to evaluate, the credibility and trauma and family relationships and power dynamics, and even things like long-term psychological harm. All right. But I feel like these laws reflect one of the central goals of modern criminal law, and that is that it's supposed to be protecting vulnerable individuals from exploitation within relationships that involve both trust and authority. So now let's talk about Megan's Law. which significantly changed how the criminal justice system monitors sex offenders after they're released from incarceration. And this law was developed after the murder of 7-year-old Megan in New Jersey. She was killed by a convicted sex offender who lived nearby, and the case generated a ton of public outrage because residents had no idea that someone with that criminal history was living in the neighborhood. So in response, states began passing laws requiring community notification and offender registration systems for certain convicted sexual offenders. Now, Megan's Law is not just one single statute, okay? The phrase generally refers to a broader system of laws regarding, registration and public notification requirements. So under those systems, certain offenders may be required to regularly provide information such as their address, their employment information, their vehicle information, their school enrollment, and basically anything else that would help law enforcement in the event that they needed to identify this person. Okay. Some jurisdictions also make part of that information publicly accessible through online databases. Now, supporters of these argue that they are necessary for public safety because they believe that communities have a right to know when potentially dangerous offenders live nearby, especially where there may be, children or vulnerable populations involved, okay? And from that perspective, registration systems help, parents and schools, law enforcement, even communities, because it takes a village sometimes, to monitor the risk and to respond more quickly if concerns arise. But those laws also generate serious constitutional and ethical debates. Critics argue that lifelong registration and notification systems may effectively create continuing punishment long after someone has completed their criminal sentence. So, for example, registered individuals may struggle to find housing or to maintain employment or develop social relationships or even to fully reintegrate into society. Okay? So some offenders become effectively excluded from entire, communities due to residency restrictions or public stigma. And that creates an important question. Should criminal punishment end once a sentence is completed, or can society continue imposing restrictions, indefinitely in the name of public safety? And that debate becomes even more complicated because not every sex offense involves the same level of danger or recidivism risk. Okay. Some offenders committed, violent predatory acts involving children or repeated sexual violence. Others have been convicted of nonviolent offenses, internet-related offenses, and even age gap offenses involving consensual relationships. Now, modern systems increasingly attempt to classify the offenders into those different risk levels, all right? But those are not, they're still controversial because predicting future dangerousness is what becomes extremely difficult, all right? While we're on the topic, another major issue involves whether or not registration systems are considered punitive or regulatory. And I know you're probably thinking, why does this even matter? And it's because if the system is considered punishment, then constitutional protections involving things like double jeopardy, due process, and even ex post facto laws become more significant. All right. So courts have often treated, registration systems as civil regulatory measures rather than additional punishment. But again, you got critics who strongly disagree with that characterization. But Megan's Law represents one of the clearest examples of criminal law attempting to balance, public safety with community awareness, with rehabilitation, with constitutional liberty, and with long-term punishment. But again, those tensions remained very unresolved today. I also want to add, while I'm here, because it doesn't come up on any of the other slides, I want to talk very quickly about civil commitment. And this allows certain sex offenders to remain confined even after completing their criminal sentences. But it's only if they're considered highly dangerous or likely to reoffend. Okay. Sometimes people very strongly react to this concept because it kind of seems to conflict with a basic assumption about people and what they think about, criminal punishment. And most people assume that once someone finishes their sentence, they're just released. But criminal commitment actually kind of complicates that idea significantly. And under many of the sexually violent predator laws, the government may seek continued confinement by arguing that the offender suffers from some sort of mental abnormality or condition making them likely to commit future acts of sexual violence. Okay. Now, technically, these proceedings are usually classified as civil rather than criminal, but that distinction still matters a lot, legally speaking, because if the confinement is considered civil treatment rather than criminal punishment, then courts have often allowed continued detention even after the criminal sentence ends. So, in these cases, supporters will argue that civil commitment protects the public from extremely dangerous offenders with high recidivism risk. And they emphasize, cases involving things like violent child molesters, repeated sexual violence, and, like serial predatory offenders, right? And from that perspective, releasing certain offenders may create unacceptable risks to public safety, period. Again, you've got critics who still raise those major constitutional concerns. And one of them is that it effectively functions as an indefinite imprisonment under another name, right? So the critics will ask, if someone has already served their criminal sentence, can the government continue confining them based on predictions about future behavior? And honestly, predicting future behavior in particularly future dangerousness, it is incredibly difficult. Mental health professionals, courts, evaluators, all those people, they cannot predict human behavior with perfect accuracy. All right? It's just the way it is. Another criticism involves the treatment itself, because civil commitment systems are often justified as therapeutic rather than punitive. All right? But critics argue that those treatments are underfunded, they're ineffective, and they're functionally indistinguishable from prison environments. Okay? So, again, the legal system faces a difficult question. At what point does preventative confinement violate constitutional liberty? And we go back to civil commitment. It reflects this larger philosophical tension within the criminal justice system. Traditionally, criminal law punishes people for conduct that they have committed, and civil commitment partially shifts towards confinement based on predicted future conduct. And that is a huge shift, both legally and ethically, and it's why civil commitment remains one of the most debated areas in, modern criminal justice, because it forces society to try to balance that mental health treatment with public protection, constitutional liberty, and even any kind of fear of future harm. And again, we're talking about something that's extraordinarily difficult with no simple answers. Well, just pretend that I said all of that over here. I'm so sorry. I should have looked ahead, but I did have it in my notes to make sure to address it. I just didn't think about looking, and that's my bad. So pause to read. Now let's talk about kidnapping. And honestly, this is one of those crimes that people often think they already understand, courtesy of movies and TV and how they portray, kidnapping constantly. But legally, kidnapping is more broad and more complicated than the stereotypical, stranger in the van scenario. At its core, kidnapping is about unlawfully taking, holding, moving, or confining another person against that person's will. It is fundamentally a crime against personal liberty because the victim is being deprived of the freedom to move, leave, or to control their own body. Okay? Historically, kidnapping required asportation, which means some sort of movement of the victim from one place to another. Now, that movement did not always have to be dramatic or cross country or anything like that. The key issue was that the victim was taken or carried away unlawfully. Now, modern statutes vary, but many of them still focus on some combination of unlawful confinement, restraint, force, lack of consent, or movement. For example, someone forces another person into a vehicle and drives them to a different location. That is the obvious version of kidnapping, right? But imagine someone prevents another person from leaving a room, threatens them that if they try and walk out, and even holds them against their will, right? Depending on the statute, that may also trigger serious criminal liability, even if the person was not moved very far at all. All right. Now, consent is extremely important. If someone voluntarily goes somewhere with another person, then kidnapping usually does not exist at the very beginning. But consent can end. If a person later says, "Take me home," or "Let me out," and the other person refuses while using force, threats or intimidation, then the legal analysis changes. So kidnapping, I forgot what I was going to say. I'll come back to it. Kidnapping also becomes especially urgent when the victim is a child. And that's where the Amber Alerts come in. Amber Alerts are emergency notification systems that are used when law enforcement believes that a child has been abducted and may be in serious danger. And the purpose is to quickly spread identifying information to the public. That includes descriptions of the child, the suspected abductor, the vehicle, the license plate, and the last known location. Now, the reason the Amber Alerts matter in this context is that kidnapping investigations are extremely time sensitive. And the earlier that law enforcement and the public can identify a vehicle, a location, or even a suspect, the greater the chances of getting that child to safety. Okay, but they're not issued for every missing child. Generally, law enforcement has to believe that there's certain criteria met, like there has to be evidence of an abduction and a serious risk of bodily harm or death. All right, that prevents the system from being overused, because if alerts are issued too often in situations that don't actually meet the standard, then the public may become desensitized and stop paying attention. So when we talk about kidnapping, we are not just talking about one criminal charge. We're talking about personal liberty, bodily autonomy, public safety, emergency response, and the legal system's, urgent role in protecting vulnerable victims. And as future legal professionals, you should always ask several questions in a kidnapping analysis. Was the taking or confinement unlawful? Was there force, threat, fraud, or coercion? Did the victim consent? And if so, was consent later withdrawn? Was there movement or restraint? Was the victim a child? And did the facts create, the kind of emergency where systems like Amber Alerts may become necessary? Now, modern kidnapping statutes often include aggravated forms of kidnapping, depending on those surrounding circumstances. For example, kidnapping becomes more significantly serious where conduct involves like ransom demands, sexual assault, weapons, serious bodily injury, terrorism, child victims, and even prolonged confinement. And historically, ransom kidnappings received enormous public attention because organized criminal groups sometimes abducted victims in exchange for money or political demands. Some of the most famous criminal cases in American history involved kidnapping. One is the Lindbergh kidnapping, and that involved the child of Charles Lindbergh. And that case generated a lot of national attention and contributed to the expansion of federal kidnapping laws. Now, you should recognize something very important about federal jurisdiction here. And if you recall our earlier discussions about interstate commerce and, federal authority, kidnapping may trigger federal jurisdiction when the victim crosses state lines, if there's interstate communication involved, if there's federal property, or if there's, certain federal statutes that apply. But modern kidnapping investigations often involve, cooperation between local police, the state agencies, and the federal authorities. Now, in particular with this slide, let's talk about parental kidnapping or custodial interference. The Parental Kidnapping Prevention Act, or the PKPA, it was enacted in 1980 to address, problems that occurred when parents crossed state lines to avoid custody orders or to search for a more favorable court. All right, so before there were stronger interstate rules in existence, one parent might leave, say, state A and go to state B to try and get a new custody order that contradicted the original one. And that just created chaos. So the PKPA requires states to respect and enforce valid child custody determinations from other states when those orders were entered consistently with jurisdictional rules. So in plain English, one state cannot simply ignore another state's valid custody order because a parent relocates or tries to relitigate custody somewhere else. All right. That means, these custody orders are only effective if they can be enforced across state lines, period. All right. Otherwise, a parent would essentially be able to weaponize geography. All right. They could take the child, move to another jurisdiction, and attempt to restart the custody fight in what they consider to be a friendlier court. But the PKPA helps to prevent that by reinforcing that full faith and credit clause from the Constitution for qualifying custody orders. Now, it doesn't mean that every custody disagreement becomes kidnapping. You have parents who may misunderstand orders, they arrive late for exchanges, or they have disputes about parenting time without committing a kidnapping offense. But when a parent intentionally removes, conceals, or keeps a child in violation of lawful custody rights, then criminal liability can arise. In parental kidnapping cases, they can be especially traumatic for children because the child is caught in the middle of two adults' custody orders. There's fear, there's loyalty conflicts, and then ultimately there's instability. So when analyzing parental kidnapping, always ask whether there was an existing custody order, whether one parent violated that order, and whether or not the child was removed or concealed. Also add in whether or not the state lines were crossed and whether laws like the PKPA are needed to enforce the original custody determination across jurisdictions. Now let's distinguish kidnapping from false imprisonment because these two crimes are very closely related, but they're not identical. False imprisonment occurs when one person unlawfully interferes with another person's liberty by using force, threats, restraints, or authority without legal justification. The key idea is confinement, okay? So a person is being prevented from leaving, moving freely, or even exercising control over their own physical liberty, right? So imagine someone locks another person in a room, during an argument and refuses to let them leave. Even if the victim is never moved to another location, that can still qualify as false imprisonment because the person's freedom has been unlawfully restricted. All right, now compare that to kidnapping. Kidnapping generally involves unlawful restraint plus some additional element, which is often movement, abduction, concealment, or, something more serious depending on the statute. The traditional distinction, though, is that asportation, which means movement. So if someone restrains another person in one location, that may be false imprisonment. But if the person is carried away, transported, or moved unlawfully, then the conduct becomes kidnapping. All right. Modern statutes do vary, and some states define kidnapping broadly enough that extensive confinement alone can qualify. But conceptually, false imprisonment is usually the lesser offense because it lacks the movement or the aggravating circumstances that are associated with kidnapping. That's why false imprisonment is often considered a lesser included offense of kidnapping. So in other words, if prosecutors prove kidnapping, they may have also proven the elements of false imprisonment because kidnapping usually includes unlawful restraint. But if prosecutors cannot prove the additional kidnapping element, such as movement or abduction, then they still may be able to prove false imprisonment, okay? So suppose a person blocks the only, exit during an argument and says, "You're not leaving until we finish this conversation." If the victim reasonably believes that they cannot leave because of force, threat, or intimidation, then false imprisonment may exist. Okay? Now suppose that same person forces the victim into a car and drives them across town. That moves the case closer to kidnapping because now we have restraint plus movement. All right. And remember that criminal charges can carry very different penalties depending on whether or not the conduct is classified as false imprisonment or kidnapping. But false imprisonment also comes up in domestic violence cases. So you might have a victim who is prevented from leaving a home, blocked from accessing a phone, they're physically restrained, or they're threatened that if they try to escape, hell will rain down. Even if an offender never transports the victim anywhere, the unlawful deprivation of liberty itself can still be criminal, okay? And it can also arise in business and security settings. So you might have a store that has limited authority to detain someone that's suspected of shoplifting, but that authority is not unlimited, okay? So if the detention is unreasonable, it's excessive, it's unsupported, or it's carried out with unlawful force, then that may become false imprisonment. So the major takeaway is this. False imprisonment, it protects personal liberty from unlawful confinement. Kidnapping usually adds movement, abduction, concealment, or additional aggravating circumstances. But both offenses reflect that same core principle that no person has the right to unlawfully take control over another person's, freedom of movement. All right, so now we need to talk about true threats. And this is where we're going to see criminal law and the First Amendment intersect. These cases can become extremely complicated because the Constitution strongly protects freedom of speech, including speech that people may find, offensive, they may be angry, disturbing, hateful, whatever. But constitutional protection is not unlimited. So certain categories of speech receive reduced or no First Amendment protection. And one of those categories is what the courts refer to as a true threat. These are generally a serious expression of intent to commit unlawful violence against another person or group, okay? So not every rude, aggressive, emotional, or exaggerated statement becomes a criminal threat. Context matters here, okay? So, for example, you have two friends arguing, during a football game, and one says, "I'm going to kill you if your team wins." Most reasonable people would probably interpret that as hyperbole or, joking frustration rather than an actual threat of violence, right? But let's say that you have someone who repeatedly sends, detailed messages describing how they plan to shoot, a former partner. Or, and actually, let's just go with that. Let's say that they include like references to weapons and location and timing. That looks very different legally because the statements appear credible and targeted and serious, okay? So courts generally examine things such as the context of the statement, the relationship between the parties, whether the statement appeared serious, whether the violence was specifically described, whether prior harassment existed, and whether or not a reasonable person would perceive the statement as a genuine threat. Okay. Now, one reason that true threat cases are difficult is because courts have to balance two extremely important constitutional concerns. And the first is, the fact that First Amendment protects, political speech and satire and jokes, artistic expression, venting, even offensive language. All right. On the other hand, the government has a legitimate interest in protecting people, from fear and intimidation, harassment, even threatened violence. And modern technology has kind of made those cases way more common and way more complicated. All right. So threats can occur through text messages, social media, gaming platforms, emails, anonymous accounts, videos, live streams. The list goes on, but, online communication creates, unique problems because tone is very difficult to interpret. Sarcasm is not always clear. Messages can spread very quickly, and then anonymous users can feel emboldened to say things that they wouldn't ordinarily say in person. All right. Another important issue involving true threats is school violence threats. All right. And those schools now confront, situations routinely that involve bomb threats and shooting threats and social media posts and threatening jokes, and students sometimes argue, I was just joking, or I didn't mean it seriously, but law enforcement and schools take those situations extremely seriously because modern history has shown that some individuals who have committed mass violence made prior threatening statements before carrying out the attacks. So investigators have to constantly evaluate, was this speech protected? Was it just dark humor? Was it a credible source of, or threat of violence, rather? And honestly, those aren't always easy lines to draw. Okay. One more thing is, the law often focuses not only on the speaker's intent, but also on the effect that the statement would have on a reasonable person. All right. So because true threats create harm, even before, physical violence occurs, it has to be weighed. So victims can experience terror and anxiety and fear, disruption of daily life, emotional trauma even, right? And society itself suffers when people feel unsafe because of a credible threat of violence. Now, one major Supreme Court issue in this area does involve determining, the required mental state. So does the prosecution need to prove that the speaker specifically intended to threaten someone, or is it enough that a reasonable person would interpret the statement as threatening? And courts continue to debate this issue because they have to balance, free expression and public safety, intent and constitutional liberty all at once, and it's incredibly difficult. And true threat laws reflects one of the hardest constitutional balancing, acts kind of within criminal law, because the legal system has to protect free speech strongly enough, to preserve liberty and open expression while also recognizing that genuine threats of violence are not simply harmless words. All right, now let's talk about cyberstalking, which has become a major issue, as technology changed the way people communicate and monitor one another. Cyberstalking involves using electronic communications or digital technology to harass, threaten, intimidate, monitor, or terrorize another person. Okay, modern technology has made stalking dramatically easier. Okay, years ago, it often required a physical proximity. But today, offenders can monitor, victims through social media, GPS tracking, fake accounts, text messaging, email, video surveillance, or even online impersonation, of somebody that they might know. And unlike traditional stalking, cyberstalking can follow victims almost anywhere because phones and digital devices are constantly connected. Now, cyberstalking may involve conduct like, sending repeated threatening messages, posting private information online, creating fake profiles, tracking locations, monitoring online activity, or even like encouraging others to harass the victim. Okay. And online harassment can become relentless because offenders can, hide behind, anonymity, or they can create multiple accounts, or they can target, victims continuously. And this here involves another issue with the First Amendment. And again, not all offensive, disturbing online speech becomes criminal. The Constitution, again, strongly protects free expression, okay, including speech that people are going to find rude and insulting and hateful and offensive, right? But the courts have to distinguish between that protected speech and the criminal harassment or the threats. All right, so the distinction, again, it's not always easy. But if you have repeated communications, expressing political disagreement or criticism, in that same realm, it can still be protected speech. But repeated targeted harassment combined with threats and surveillance or fear or intimidation, that can cross into criminal conduct, okay? Another thing here to discuss is the fact that cyberstalking is digital permanence, okay? Once information is posted online, it can spread rapidly and become almost impossible to fully erase. So victims of cyberstalking can experience fear and anxiety and reputational damage. They can have employment consequences and, of course, emotional trauma. And these cases often overlap with like domestic violence, identity theft, even true threat cases, and even revenge pornography. Okay. And both the state and federal statutes exist addressing cyberstalking because, digital harassment often crosses state lines, multiple platforms, and even through multiple jurisdictions. And criminal law is constantly trying to adapt to technological change. Stalking, the stalking laws, rather, they kind of demonstrate how criminal justice has increasingly recognized that serious harm can occur through, this obsession, this fear and surveillance and this, psychological intimidation, and that it's not always just physical violence. All right, now let's talk about civil rights crimes and hate crimes. These involve some of the most difficult constitutional balancing in criminal law. Generally speaking, hate crimes involve criminal conduct that's motivated by bias against protected characteristics like race, religion, ethnicity, sexual orientation, national origin, gender, or disability. Okay? And sometimes people misunderstand hate crime laws and think that people are being punished merely for hateful thoughts or offensive opinions. And that's not generally how these laws work. The First Amendment protects many forms of offensive speech and hateful beliefs, okay? The government usually cannot criminalize someone simply for holding, a racist opinion or even just a hateful opinion. But when criminal conduct is motivated by bias and intimidation, then additional criminal liability or sentence enhancement can apply. All right, so let's say that you have two assaults. In one case, two people get into a random fight outside of a restaurant. In another case, someone targets a victim specifically because of the victim's race or their religion while using slurs and intimidation. So the physical assault may appear similar on the surface, but the hate crime statutes recognize that bias-motivated violence often, harms not only the direct victim, but also entire communities. Okay? And that's what makes these offenses, that's why they're, I guess, more often viewed as especially serious. Now, federal law criminalizes conspiracies where there's two or more persons who injure, oppress, threaten, or intimidate someone for exercising their federally protected rights. All right. Historically, those laws became extremely important during the civil rights movement when violence and intimidation were often used to prevent individuals from doing things like voting, going to school, participating in public life, or exercising equal protection rights. All right. And as you can see, it mentions Rodney King. He was beaten by the Los Angeles police and became one of the most famous civil rights cases in modern American history. After state acquittals generated widespread outrage and unrest, and I mean widespread, federal civil rights charges were later brought against the officers. That demonstrated how federal civil rights statutes can sometimes apply even after state proceedings. Okay. Another major issue here is it's about freedom of expression. So remember that offensive speech alone is often constitutionally protected, no matter how much we like it or don't like it, okay? The Supreme Court has repeatedly held that even hateful expression may receive First Amendment protection unless it crosses into categories such as true threats, also into incitement or unlawful intimidation. And the court has said that speech advocating violence generally cannot be punished unless it is intended and likely to produce imminent lawless action. That brings us to another case called Brandenburg v. Ohio. And that is one of the most important First Amendment cases involving extremist speech. But the court has also recognized that states can punish conduct that is intended to intimidate so long as the law operates in a viewpoint neutral manner. All right. That's why this is one of the hardest constitutional balancing acts in criminal law, because how do we strongly protect freedom of expression while also protecting individuals and communities from intimidation, violence and targeted terror? Again, we're talking about there being absolutely no easy answers. All right, so as we finish up this chapter, let's talk about ethics and professional responsibility. One thing that students forget sometimes is that criminal law doesn't just affect whether or not someone goes to jail or gets put on probation or something like that, but criminal conduct and sometimes even just deeply unethical conduct that doesn't result in any kind of conviction. It can also affect things like employment, your professional licensing, your reputation, security clearance, and even things like admission to the bar. Every state bar association evaluates whether or not applicants possess what they call, good moral and character fitness, right? It's your character and your ethical fitness to, practice law. And it goes beyond simply checking whether or not someone has had a criminal conviction. So bar examiners can examine dishonesty, fraud, financial misconduct, academic misconduct, substance abuse issues, violent conduct, or patterns of discriminatory behavior. All right. And the reason is simple. Lawyers occupy positions of trust. And attorneys handle things like client funds and confidential information, constitutional rights, court proceedings, and even just access to the system itself, right? So the profession imposes ethical expectations beyond ordinary citizenship. So as you see, it talks about a vocal racist being denied membership to the Illinois bar. Cases like that create major constitutional and ethical questions involving free speech, freedom of association, bias, and even professional responsibility. All right. Maybe you can't, and maybe you can't, but do you see the tension here? The First Amendment generally protects even offensive, beliefs and speech. So someone can be denied entry, into a profession based on racist expression or extremist viewpoints, and courts and bar associations often analyze whether or not that conduct reflects, bias and their inability to fulfill professional obligations fairly, or the lack of fitness to uphold ethical duties that are owed to clients in the justice system. And that, again, raises difficult questions. Should private beliefs matter if someone can still competently perform their legal work? Or do certain expressions of hatred fundamentally undermine public trust in the legal profession? Reasonable people disagree very strongly about where those lines should exist. But ethical discussions like these are important because criminal justice professionals exercise enormous power over liberty and fairness, and public trust and even equal treatment under the law. So throughout your legal career, your ethical responsibility, honestly, will matter just as much as your technical legal knowledge. And that's really all I have for you guys today. Please reach out if you have any questions. Bye.